Let's make this plain and simple, man. You don't need the whole courtroom. You don't need the jury. You don't need, hella objects, 11, 12 dozen objects. You don't need a 100-page motion. We don't even do motions, man. The judge in chambers, that's really all you need. Because under equity, that quiet room, that off the record, behind the scenes space, that's where the real power lives, all right? Not less court, more court. Why? Because the judge in chambers, it holds an ancient mantle, the same authority the chancellor once held in England before the statutes, before the codes, before the courtrooms became a theater. They've been telling you since the 1700s, the world is a stage, you know what I mean? That room, the chambers, that's equity's domain. That's the seat of God's discretion, of conscious mind, of justice beyond the letter. And Pomeroy said it best. Individual judges acting in chambers have all the powers the chancellor had. Let that settle in. One judge, full discretion, the God-like mind discretion. That's what you want. Let that settle in. Think about it. Let that settle in. Just one judge, man. Full discretion. The God-like discretion, all right? No jury, no codes to hide behind, only the call to really administrate justice, because that's what this is about, you know what I mean? When the law falls short, you gotta do what's righteous. And then Gibson, he backs it up too. Henry Gibson, suits in chancery, he backs it up too. He tells us the judge in chambers, right, they can do everything from hearing your smallest motion to actually executing the final remedy. I've actually experienced that helping people, and I've been a part of other cases too. So why does this matter? Because the federal courts, that's the highest level, they have always actually known the truth. It's these lower courts that don't necessarily know what you're talking about, don't have the jurisdiction. So equity, exclusive equity jurisdiction, it does not apply when there's already a full and adequate, legal remedy. So what does that mean? It means you don't invoke equity just because. You invoke it when the system fails you. When the law applies strictly, it leads to harm. That's why I educate you to actually make sure every time you express yourself, you're actually creating that conflict so that you can go into equity, because there's always no adequate remedy at law for you. You're always being harmed. We on the same page there? Are y'all picking up what I'm putting down, man? Listen, when checking out the boxes, right, still leaves you broke, still leaves you bruised, still leaves you buried, right? That's when exclusive equity steps in. Because exclusive equity, it was never about the form. It's about the outcome. It's about being righteous, about making everybody whole. Now here's the key to the kingdom of exclusive equity, right? All courts run on two things: waiver and consent. Let that sink in. You see, if you don't challenge the rules, you just agree to them. Silence is consent too. So all you people just not showing up to court and everything, you acquiesce, you agree to it. But exclusive equity, it offers a way out. It's a light at the end of the tunnel. You pick it up what I'm putting down, man. Listen closely to what Minnesota rules of civil procedure say. In furtherance of justice, the rules may be relaxed or modified in any case, or a party relieved from the effect thereof on such terms as may be just. Look, that's not just legal fluff. That's actually your remedy if you actually understand it. If you got the equity eyes to understand it. I might have been paraphrasing there, but that's basically what it said. So that's where the form drops in, and the conscious God-like mind actually takes over. That's where the law yields to the principle where performance matters more than the paperwork, all right? It's the substance that truly matters. But only if you ask and you question things and you express yourself, all right? Only if you know how to invoke exclusive equity. You gotta know how to invoke exclusive equity. Because if you stay silent, you stay under statute, you stay under form, you stay under the weight of a system, of a matrix that was never designed to see you, you're gonna continue to feel oppressed, man. But if you speak up and you speak in exclusive equity, right? If you claim, you know, the fairness, the righteousness, the substance of reform, the courtroom actually can become a trust. You can actually position yourself to be the beneficiary of a trust, you know what I mean? You become the man or woman holding the beneficial interest. That's the power of the chambers. That's the throne, the room of equity. That's where you want to be. So the next time they try to box you in a corner, right? Try to back you in the corner with codes, rules, statutes, with processes, don't fight it. Don't even flip. Just say one line. In furtherance of justice, ask the court to relax the rule and administer exclusive equity. Simple, direct, unshakable, unbreakable. Got bars for y'all today, man. Listen, because when you come with clean hands, when you ask in truth, and when the law isn't enough, exclusive equity, it gotta show up, man, in your favor. It gotta answer the call. And the court has no choice but to open the door for exclusive equity. Listen, Pomeroy said it best. When there's a conflict between the rules of law and the rules of equity over the same subject matter, the rules of equity always prevails, man. This is why you need to know your rights. This is why you need to know exclusive equity. We got a class coming up. It's gonna be intense. But listen, click the link in the description. I'm gonna let you boost so you know who you are under the Constitution, know what rules apply to you. You can make this investment in yourself and your future so that you can pass it on to your kids, your grandkids, and future generations so we can push this entire narrative forward, man. I'll see you in class. Let's get it.